change chairs. These kind of take up
okay.
a lot of space. Purple. I don't want you guys to be totally crunched. That's that. Okay, which one is that one? And you know you could turn it off and
Yeah.
on. Okay. Yeah, if I would just take it all off. Yeah, you could just mute them all. And again, a lot of times they just do it themselves because they could do it. They have the capability. Thought you could do it all at once. Yeah. Uh-huh. The judge's office.
Test. Testing. Testing.
You gotta get closer.
Testing.
Yeah, it's
Okay.
you mean unmute?
Testing, yeah. Testing. Testing. Right. Yeah. Okay.
we just got some new exhibits from the taxpayer. I was wondering if FTB, do you need about 10 minutes or? Okay, so we'll give you a few minutes to look at those and then we'll discuss.
These are originals. These are already have. Come over here, let's get away from the mic.
It's not been 10 minutes, but are you ready to start?
Yes.
Okay.
I can have 2 minutes to.
Yes, you can have 2 minutes.
I had made copies, but I didn't make enough copies for everybody.
morning. Thank you for coming here today. I'm going to ask for the case to be called.
This case is Conrad E. Dandridge, case number 1-804-2751.
All right. My name is Amanda Vasig. I'm the lead judge in this case. I'm here with my co-panelists, Jeff Njija and Tommy Lung. We'd like to have the parties introduce themselves, please. State and spell your name.
Conrad E. Dandridge, C-O-N-R-A-D. Last name is D as in David, A-N-D-R-I-D-G-E.
Thank you.
David Kowalczyk for the Franchise Tax Board. DAVIDKOWALCZYK.
Nancy Parker for respondent.
And Mr. Dandridge, I'd like to confirm you have no witnesses today.
I have no witnesses.
Okay. Well, before we go on the record, which means that our court reporter will be transcribing our hearing, I'd like to briefly emphasize a few highlights. This is an informal hearing, and the judges on the panel have read all the documents the parties provided in advance. We're aware that we have some new documents this morning to look at. Our goal here today is to provide the parties with a fair and efficient hearing. To that end, we'll be following certain guidelines to ensure that we establish a proper record on which a decision may be based and to conduct an orderly hearing. We've gone over what to expect today at our pre-hearing conference. As a reminder, Mr. Dandridge has elected to present an opening statement. Does the FTB intend on presenting an opening statement as well?
No.
Okay. When we do go on the record, we'll begin with Mr. Dandridge's opening statement, and then Mr. Dandridge, you'll have 10 minutes to present your testimony portion. FTB will have 10 minutes to question you, and then the parties will have 10 minutes each for closings. And Mr. Dandridge, you'll have 5 minutes at the end if you have any rebuttals or final remarks. Myself and my fellow panelists may ask questions from time to time. We try to do it in a way that doesn't break up the flow of the presentations, but we just want to make sure that we understand exactly what you're saying. Fair warning, I may interrupt you if we get out of order or become counterproductive. My role is to just keep us on track and create a clean and efficient hearing record. If at any time you need clarification or you have a question, please direct your questions towards the panel. Do we have any questions before we go on the record? Okay.
One question. Can I stand?
You can stand.
Okay.
You can do whatever you feel more comfortable with. And FTB, you took a little bit of time to look at some new documents that Mr. Conrad would like to enter. Do you have any objections to that?
No objections.
Okay. So we are now going to go on the record. We're opening the record in the appeal of Conrad Dandridge before the Office of Tax Appeals in case number 180142751. Today is January 29, 2019, and the time is 9:16 a.m. This hearing is being convened in Sacramento, California. Today's case is being heard by a panel of 3 judges. My name is Amanda Vasig, and I will be acting as lead judge for the purpose of conducting the hearing. Tommy Lung and Jeff Njija will also be participating in the hearing. We have read the briefs and examined the exhibits that were produced beforehand. All 3 judges will be tasked with making a decision in this matter as equal participants. Although I may conduct the hearing, any judge on the panel may ask questions and otherwise participate to ensure that we have all of the information needed to make a fair decision. So let's have the parties state their appearances for the record. Mr. Dandridge, please state your name.
Conrad E. Dandridge.
And I already asked you to spell it, but I'm going to ask you again for the record.
Conrad,
Apologize.
C-O-N-R-A-D. Dandridge, D-A-N-D-R-I-D-G-E.
Thank you, and representing the FTB.
David Kowalczyk.
And I'm going to ask you to spell it again. I'm sorry.
DAVIDKOWALCZYK.
Thank you.
And Nancy Parker for respondent. Nancyparker.
Issue on appeal is whether a Appellant, Mr. Dandridge, is entitled to claim a deduction for the mortgage insurance premium for the 2012 tax year. It's my understanding, based on our pre-hearing conference, that there were no objections to the exhibits previously submitted, and there are no objections to the exhibits Mr. Dandridge would like to submit this morning. Is that correct?
Correct.
And Mr. Dandridge, you have no objections to the FTE's exhibits? Okay. So we have respondents' exhibits A through E listed in the exhibit log before you. And Mr. Dandridge, you also have what was presented to us as two packages. Are these,
They're going to, I'll identify them as I go through today.
okay, but we'll need to identify them now. We'll mark them now as F and G.
Correct.
Okay. So F is the personal income tax booklet for 2012.
Correct.
And Exhibit G is this package. How would you describe this package,
There
Mr.
are
Dandridge?
information on definitional terms and also clarifications to the law.
Okay. So your research package?
Yes.
Okay. So Exhibit G is your research package. So, Mr. Dandridge, if you can take a second to look at the revised exhibit log and the copies of the exhibits F and G before you, and just confirm that this is what you expect to see in the record.
Yes.
And FTB, can you confirm for the record there are no objections to any of these exhibits?
No objections.
Thank you. Exhibits A through G are now admitted into the record. I referred to those initially as respondents' exhibits. They were appellants' exhibits. And we have respondents' exhibits 1 through 3. Mr. Kowalczyk, does this reflect what you expect to see in the record?
1 through 3 is actually appellant
All right.
exhibits.
You're right. So, So let me make a correction to appellant's exhibits. That would have been 1 through 3 previously submitted. 4 is the 2012 booklet, and 5 will be the research package. So exhibits 1 through 5 are now admitted into the record. And respondents' exhibits are A through E. Mr. Kowalczyk, does that reflect what you expect to see in the record?
Yes.
Thank you for the correction, by the way. And Mr. Dandridge, can you confirm for the record that there are no objections?
There are
to
no
these
objections
exhibits?
from me.
Exhibits A through E are now admitted into the record. We'll now begin with Mr. Conrad's opening statement. As discussed previously, you'll have 5 minutes for that opening. Please keep your opening to an explanation of what you intend to prove during the evidentiary portion of the hearing. Mr. Dandridge, I'm going to swear you in now, and you will remain under oath until the hearing is over. So please stand and raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please begin when you're ready.
Good morning. I'm walking into this hearing room with a little bit of, I'm a taxpayer. But let me give you a little background about myself real quickly. At 13 years old, I spoke out against Prop 13 in front of 10,000 teachers at the Oakland Coliseum with Willie Brown and Gray Davison in attendance. I went to college at University of California, Berkeley, served in the Air Force Reserves, and then went on to work for the Department of Justice with the Drug Enforcement Administration, doing a detail at the National Security Administration where I briefed President Clinton 3 times on narco-terrorism. I came back after working in the U.S. Attorney's Office. I worked for the Contra Costa County Administrator's Office. I did some teaching, worked for the County Office of Ed, worked for the Bureau of Census. In the last 17 years, I've been an analyst with either TSA or presently I'm with Customs and Border Protection. And yes, I just returned to work yesterday. But what I want to cover here is that what I'm looking for is for you to affirm that I'm entitled to the deduction of my mortgage insurance premium that was paid to the Federal Housing Administration. There are a lot of errors here. I have a lot of questions. You're going to have a lot of questions because we need to figure out who is correct, who is making a mistake, because somebody's made a mistake here. In one of the pieces of paper, the notice of action that was sent to me by the Franchise Tax Board, it reads that the taxpayers are required to follow the law, not the instructions. Wow. If every resident in the state of California was required to know every little bit of the law, why do we need the Franchise Tax Board to put out a tax booklet? Just send out the state constitution and you have to go from there. And I get it. They represent that this tax booklet from 2012, 68 pages, is an authoritative law. But as a taxpayer, as a public servant, we are required to give a duty of care. I expect a duty of care from the Franchise Tax Board. We need to look at the law, the instructions, and legislative intent. We're going to look at things from the Franchise Tax Board making mistakes in their brief, in the responses to me, and the publications to the public. We're going to talk about the failure to follow state law, if they failed. Did they fail? Maybe they didn't fail. Failure to do their duty of care to us. I looked at their brief, and their brief prints out tax information about me, but it wasn't from when they did the audit. It was from 2018. Where's the 2016 documents that they used to determine what was wrong? All residents of the state of California have a responsibility to follow the law, but they also are owed a duty of care from public servants. Panel, I've raised my hand and took an oath to defend the Constitution since I was 18 years old. In my job with Customs and Border Protection, we are the second largest revenue collecting agency in the country, and our history is based on those revenues that Customs takes. If I give the wrong information is blamed on me as the deliverer, as the public servant, as the professional. We're going to cover certain terms today, things like legislative grace, which is thrown about. But let's talk about legislative grace. Let's look at the fact that in my testimony, in my documents, you see that I've done everything timely, on time, not making any mistakes. My tax return is done by hand, and it's legible. And why would I make a mistake? I'm audited every year from the IRS because I have a national security clearance. The IRS doesn't come after me. What I look for at the end of this hearing is to give you information so you can make a fair and balanced decision that I followed the rules and I'm entitled to the deduction for the mortgage insurance premium I pay to the federal government. Because in my documentation for 10 years, the Franchise Tax Board refers to the term private mortgage insurance. And in my exhibits, I show from 2001 through 2016, they knew the difference between what was private and what wasn't. They don't define what is private. They depend on the Internal Revenue Service to do that. And U.S. Code 26 defines what is private and what isn't private. Now, they banty around terms. Some of the exhibits I just gave you, and I'll refer to that, is where the terms get mixed up. But what is private is pretty much a bright line. Private is pretty much a bright line. Private is not public or government. What my insurance was insurance that was ordinary and necessary for me to have a mortgage through the Federal Housing Administration, which was created in 1939. Until recently, the Franchise Tax Board's instructions have not changed. So who's making a mistake? Who's following the law? We're going to look at those things. We're going to have a lot of questions. And a lot of the information I have for you is going to bear out the points that I'm making. Who I am, I'm a public servant. I come from parents who are public servants, a family of public servants. By statute, I am to pay my taxes. I am not to break the law. At the end, we're going to have to look at certain types of ethical choices. Are there sins of commission, sins of omission, or maybe there's just misunderstanding of what the law is. Did the Franchise Tax Board actually define what the law was? Because that's their job to do for the legislature. Did they do it? Maybe they didn't make a mistake in the book. Maybe the mistake was made by the folks that were looking at my tax returns. Maybe I did everything right. All I know is that I followed the instructions because that was what the information was. The information says to check the conformity website, to check the conformity booklet. And in the conformity booklet, the 101, the 1001 booklet, which is part of the exhibit, the term private mortgage insurance was used. I'm here today as a public servant pointing out a mistake. My last job that I was sworn into, my boss, I won't use the exact language he used, was I have 3 rules. Don't foul up, don't foul up, don't foul up. If you do something because you're trying to do something the correct way, I will back you 100%. But if you do something because you're trying to avoid it, or you're trying to omit it, or you're trying to get away with it, I will drop kick you into the next century. So you're standing before you is not an ordinary taxpayer. It's a taxpayer who is a public servant and understands the duty of care owed by public servants, like all of us, to the residents of the state of California. Thank you.
Thank you, Mr. Dandridge. We will now move on to the evidentiary portion of today's hearing, and we will begin again with Mr. Dandridge. I'm going to invite you to testify and explain your position.
I received a letter in 2016 stating that I had failed to follow the tax instructions. And I provided information stating that I had followed the tax instructions. And the first response I got back was a misstatement of California law. And I went to that law, Revenue and Tax Code 17225. In the response from the Franchise Tax Board, it says, under California law, mortgage insurance premiums are not treated as interest paid on acquisition indebtedness of a qualified resident and not deductible. After this time, I reached out to my local members of the state legislature who provided me Senator Bill Dodd, Assemblyman Tim Grayson, and at the time, Board of Equalization member Fiona Ma. And they provided me some information. I also spoke with the Franchise Tax Board representative. With the Board of Equalization, he pointed out that there may have been some communication or miscommunication about what mortgage insurance is and looking to the federal law. So in looking at the brief, and in the notice of action, they point out that deductions are a matter of legislative grace and the burden is on the taxpayer to prove expenses are within the terms of the statute. So being a novice, I had to go look up what legislative grace is. And legislative grace was actually defined by the Supreme Court as any tax relief provided to taxpayers as a result of specific acts of Congress must be strictly applied and interpreted. All income is received is taxable unless there's a specific provision that can be found in the tax law that excludes the income from taxation. Deductions must be approached with the philosophy that nothing is deductible unless there's a provision in the tax law that allows the deduction. Now, please
Mr.
understand.
Dandridge, sorry, are you referring to one of your
Yes.
exhibits right now?
It's in the research packet,
Okay,
and it should be marked with an A1.
thank you.
Now, understand that that concept refers to the term legislative grace. Let's look to the Franchise Tax Board's brief. They cite 2 Supreme Court cases. I'm not sure why they support them. They cite them, or 1 Supreme Court case and 1 Board of Equalization case when they talk about legislative grace. The Supreme Court case deals with business expenses in 1992, looking at the concept of ordinary and necessary business expenses. We're not talking about business expenses. We're talking about mortgage interest deduction.
Which case is that?
This is the Indicopo Inc. versus Commissioner, which is cited under the Franchise Tax Board's position in their brief. They also cite an appellate case before the State Board of Equalization that deals with, again, business expenses. Then they go on to cite two more Supreme Court cases, Welsh versus Heverling, which really deals with that concept, as Justice Cardozo said, the concept of ordinary and necessary business expenses. And then another appeal case that deals again with business expenses. So I'm not quite sure what they meant. But I think what they were trying to say is legislative grace. Legislative grace was a concept first coined by the Supreme Court. It refers to Congress because Congress has an express and absolute right to create tax law in the United States, given to it by Article 1, Section 8 of the Constitution and the 16th Amendment, where it says Congress shall have the power to lay and collect taxes on income from whatever source derived without apportionment among the several states and without regard to any senses of enumeration. Just in White versus U.S., the Supreme Court said this is an absolute power. During the battle over the Affordable Care Act, they stated in a brief from the Washington Legal Foundation that the IRS has relied on the legislative grace canon to deny taxpayers deductions, credits, and exemptions whenever it is unclear that the tax code prevents them. So these are all cases at the federal level. What about the state of California? Does the California legislature have absolute authority over tax matters? No, they don't. The Constitution, which is included in their packet, Article 13 of the California State Constitution, Section 26A, states taxes on or measured by income may be imposed on persons, corporations, or other entities prescribed by law. Compare that to the U.S. Constitution with the word shall, may or shall. But something else popped up. Who else in California has the right to offer up law? We, the residents of the state of California. In my research packet is an article or a piece from the California State Attorney General's office that says ballot initiatives can be offered up bypassing the governor and the legislature, going directly to the people to create law. Proposition 13. Perfect example. So the canon of legislative grace is not an absolute one. At the federal level, yes. At the state level, no. Even the California Supreme Court in some of their rulings has stated that there's some question on where that legislative grace canon lies. So let's look at some of the other mistakes. Say that mortgage insurance premiums are not deductible. Look in my earlier exhibits. I offered up information from 2001, an Assembly Bill, AB 273, where they were talking about private mortgage insurance. And then they said, oh, we have people that have things that aren't private mortgage insurance. VA, FHA, rural housing. And they amended the analysis. The bill didn't go anywhere. Private mortgage insurance had never been deductible off your federal income taxes until the passage of the Homeowners Protection Act, which defines what private mortgage insurance. Please understand, the Franchise Tax Board and the state legislature does not define these terms. They rely on the federal government to define the terms. In the research packet, you'll find articles on what FHA insurance is, what VA insurance is, and what rural, which is now referred to as USDA. The differences between private and mortgage, which is one of the articles I provided to you earlier in one of my packets, an article on private mortgage insurance. And what is a qualified mortgage insurance? These are all discussions I had with the Franchise Tax Board representative embodied with the Board of Equalization. Now, going to the brief from the Franchise Tax Board, there's some contradictions. In the brief, under the position, he states to reconcile the difference between federal treatments of the MIP expense. I'm not sure where the MIP expense is described in any of the tax booklets. You are required to subtract your MIP expense on line 41 of Schedule A. I'm not quite sure where it says that. The actual language in the tax booklet, which you guys have in your exhibits, states, if I had private mortgage insurance PMI, bright line, private mortgage insurance. Private, meaning not of public, not of government. Then he goes on to state, even though the Schedule A instructions specified that only taxpayers who paid private mortgage insurance should add the amount of premiums on line 41, the FTB can appreciate the language in the Schedule A instructions was not as broad as it should have been. Not as broad as it should have been. 2007, 2008, 2009, 2010, 11, 12, 13, 14, 15, 16. They use the same language. Private mortgage insurance, PMI, needs to be removed from line 47. Same language. Hold on. When you go to the book that they put out, the instruction book, and they tell you, this is the actual 2012 book. They have all this information on what's new and important information in 2012. They talk about the mortgage forgiveness debt relief extended. They talk about the mortgage credit, but they don't say anything about the mortgage insurance premium. They tell you that if you need to figure out what's the difference in conformity, you go to the website. I pulled the website as part of the exhibits. They tell you to go and look in the booklet that describes the differences in detail between federal and state law. 2008, 9, 10, 11, 12, 13, 14, 15, and 16. That booklet refers to private mortgage insurance and tells you to go back to the instructions in this booklet to figure out anything else. The booklet is their representation of the law. Sure, it's not authoritative law. So let's look at the law. The law says mortgage insurance premiums, according to the IRS section quoted, shall not be treated as interest. But the law also says that the Franchise Tax Board has to present an analysis of that law prior to that law becoming law. And in the analysis of the law by the Franchise Tax Board themselves, they use the term private mortgage insurance. The extension of private mortgage insurance will not conform. Not mortgage insurance premiums, not qualified mortgage insurance, private mortgage insurance. Go back, 2007, summary of income tax changes. They talk about the extension of the treatment of mortgage insurance premiums as interest. They talk about qualified mortgage insurance. This is their work. Mortgage insurance provided by the veteran, the federal housing, rural, and private mortgage insurance as defined under Section 2 of the Homeowners Protection Act of 1998. They also use the term qualified mortgage insurance. But then they go on to talk about the federal law extending the deduction for private mortgage insurance. They don't say that the law extended the deduction for anything else. Private mortgage insurance. Then they go on and they start talking in the conformity tables. Extension of private mortgage insurance. Conform with objection. So the Franchise Tax Board is objecting to the confirmation. They make a typo. They say 2 objections. Allowing the deduction for personal, they meant private, mortgage insurance, subsidizing taxpayers who choose this type of mortgage. And 2, PMI should not be allowed as a deduction as it is one of the contributing factors that led to the foreclosure crisis. Well, that's the same language they used in 2001 when debating whether to have private mortgage insurance deducted off the state taxes. All in the record that I provided to you in the exhibits. It's all there. The federal statute makes a clear, bright line definition of what they consider to be mortgage insurance. In the public law, which is in 1, it is in my original exhibit packet, and 2, it is in the research packet because I went back and found the actual law from 2006 and 2007. It states that mortgage insurance, qualified mortgage insurance, is mortgage insurance provided by the Veterans Administration, the Federal Housing Administration, and the Rural Housing Administration. 2, private mortgage insurance is defined by Section 2 of the Homeowners Act. Now, what does the law say? What is the interpretation of the law? Well, the Franchise Tax Board in 2013 actually published, because this morning I decided that I was going to go back and find the actual tax documents, because those actual tax documents were not provided by the Franchise Tax Board, by the IRS. So you have a copy of it. You have a copy of my Schedule A. You have a copy of the information from Wells Fargo on my 1098. And at the bottom it says, recent passage of the American Taxpayers Relief Act may provide additional savings to homeowners, and they've extended the mortgage insurance premiums. So now, I'm like, okay, let me do some more research. The booklet says private mortgage insurance. The law is referring to mortgage insurance premiums treated as interest, because that's the title of the IRS code section, which goes into detail. On the tax STRS form, it says qualified mortgage insurance. So what are we talking about? What are the definitions? That's why I provided you the research packet, because they used to give you clear ideas. MIP, PMI, but PMI is regulated by the state of California. Civil Code, Division 3, Part 4, Title 14, Chapter 2, Article 2. The state of California regulates private mortgage insurance. Do they regulate EA, FHA, RHA? No, they don't. I provided you exhibits. I provided you some definitions of what a qualified mortgage insurance. Qualified mortgage insurance is that insurance is paid to the federal government. Private mortgage insurance is paid to a private company. There are certain rules and regulations. If we take the Franchise Tax Board's 2 Supreme Court cases and you look at the arguments of ordinary and necessary, mortgage insurance is ordinary and necessary to have a VA alone. It's called funding fees. For FHA, it's called mortgage insurance premiums. For RHR, because those programs were set up to foster home ownership throughout the United States by those wise 538 people on the Hill who had absolute right to do so. California is trying to conform. State law says that California's Franchise Tax Board, and this is one of the exhibits that I provided early on, states that it is the responsibility for both, that they have to do it. They don't even have a choice. They have to provide a final analysis of the law, and it has to be sent to the public and to the state legislature. We have a copy of their final analysis. The terms are used private mortgage insurance. But in 2013, something else happened. What happened in 2013? Oh, the Taxpayers Act. And when there's a change in federal law that may affect conformity, the Franchise Tax Board is required to report to the state legislature. And they did so. And the language that they used in that document reads as this. Private mortgage insurance. Federal law. The provision extends the deduction for private mortgage insurance premiums for 2 years. Then they go on to state California law. The personal income tax law specifically does not conform to the federal deduction for private mortgage insurance premiums. As a result, private mortgage insurance premiums are not deductible under California law. This is a document from the Franchise Tax Board. Controller Chung submitted this to the legislature. In my interviews with Steve Palanges, a legislative aide to Senator Bill Dodd, he's like, we make sure we're going over this. The lawyers are going over this. They're making sure everything's right. In 2013, Franchise Tax Board stated clearly, bright line, specifically, private mortgage insurance is not deductible. That matches what is in their booklets, in their instructions, in their analysis. Then all of a sudden in 2016, they come back and say, Mr. Dandridge, you can't deduct your mortgage insurance premium. My response is, because private mortgage insurance isn't deductible. I didn't have private mortgage insurance. I had a mortgage insurance that was qualified because it was part of the deal the federal government made to assist me in purchasing my first home. And the rules and regulations that I had to follow, the lenders that I had to do, specified by federal law. Wasn't private. It wasn't because I chose not to put down 20%. I was a first-time homeowner. I was having a kid. I was a public servant. So the questions are, what is qualified mortgage insurance? The state doesn't define it, but the federal government does. They define it clear and bright line because that's their job. Their job, Congress, is to make tax law. I reached out to a friend of mine I went to college with. She was a deputy counsel for the Senate Finance Committee during this time. She now works for the IRS, and the IRS part that looks over state taxes. And she basically said, Conrad, you're right. It's private mortgage insurance because it's defined by the federal government and in the state documents as being defined by the Homeowners Protection Act. It's not mortgage insurance premiums. Now, the whole title of the section is defined as mortgage insurance premiums, but the Franchise Tax Board has already come out and said, no, it's private mortgage insurance. And they've said that multiple times. 2001 bill analysis, 2007, 2010, in the final analysis to the state Senate. 2013, after there was another federal law change, because they were meeting the terms that the state legislature puts out that says they must do this. It was public. Me as a resident, I'm doing my taxes, I'm doing my due diligence, I have the tax booklet. I wonder how many residents in the state of California still have their 2012 tax booklet. Not many, but I do, because I keep all that stuff. And when I flip to it, which you have a copy of it, it says, line 41, they have a lot of information in here. Mortgage interest credit, business expenses, investment income, gambling losses, health savings account, private mortgage insurance. If you took the deduction on Federal Schedule A, Form 1040, line 13, then subtract the same amount, line 41. Fact, I did not have private mortgage insurance. Fact, the Franchise Tax Board has deemed that private mortgage insurance is not deductible. They didn't say qualified mortgage insurance. They didn't say mortgage insurance premium. Legislative grace, it applies, but it's not an absolute. The state legislature depends on the Franchise Tax Board to provide them the correct information in the analysis of the bill. Senator Dodd's office said, if that's what they said in their analysis, that was a legislative intent. Look to the law, he said to me. His chief of staff said it to me. His legislative analysis helped me, analysts helped me find the actual state law to make sure I was finding what I needed to find. That's what the law says. The Franchise Tax Board's interpretation of it has now changed from 2013 to 2018. Does the state legislature know that it's changed? Have they done a new analysis of it? Because all the evidence is saying private mortgage insurance. Why? Because private mortgage insurance was bad. Federal qualified mortgage insurance, you've got the packets on the history of the FHA, the VA, and the USDA, why they were created, what they were used for. They weren't done to help people get away with stuff. They were done to help residents, citizens buy a home. This may come down to definitions, legislative intent. But the Franchise Tax Board has been pretty clear from a bright line standpoint of what was deductible and what wasn't. And now to come back and say, whoa, legislative grace means the burden's on me? Okay, if we were dealing with federal tax law, darn straight. But tomorrow, all of us could get together. We could write up tax law. We could send it to the Attorney General's office. We could get enough signatures, and we could create tax law in the state of California, which means the legislature does not have exclusive claim to tax law. State Constitution uses the word may, not shall, not must. So legislative grace, it may apply, it may not. The cases that the Franchise Tax Board have put it in their brief don't apply. But the contradiction stands out. Where does it say, I was required? He says, you were required to subtract your MIP expense. Where does it say that? Then it sums down and says, and I don't know which is worse. The statement, taxpayers are required to follow the law and not the instructions. So if I'm driving down the road and I see a speed limit sign and it says 65 and I'm doing 60 and I get pulled over doing 60 and a 55, what's going to happen? The speed limit sign said 65. Or Franchise Tax Board can appreciate the language in the Schedule CA instructions was not as broad as it should have been. Maybe that was a mistake for 1 year. But remember, 10 years, you've got them. You got copies of the paper. You see the revision dates. Some of the revision dates are after they were issued. You've got the copies of the publication 1001 that says at the top, the differences between state and federal law. Does it say mortgage insurance premiums? It says private mortgage insurance. Are you telling me that lawyers weren't looking over these publications? That this went unchecked for 10 years? Because if that's the case, holy Toledo, we better start looking at everything with a microscope. Because I know if my boss was in charge, somebody's head, somebody's you-know-what would be kicked into the next century. Or maybe they got it right, and they're getting it wrong now. That's the decision that you guys need to make.
Thank you, Mr. Dandridge. We went over time a little bit. I just wanted to give you the opportunity to present your whole position. We'll go to the FTB now, and then you will have a brief rebuttal opportunity, but we'll keep that one within the time limit. Mr. Kowalczyk, whenever you're ready.
Okay. Good morning. The issue before us today is whether Conrad Dandridge met his burden of proof to establish he is entitled to claim a deduction for mortgage insurance premiums for tax year 2012. After Mr. Dandridge timely filed his 2012 tax return, the Franchise Tax Board received information from the Internal Revenue Service showing that he reported a $6,737 deduction for mortgage insurance premiums. The Franchise Tax Board then proposed to assess additional tax because Mr. Dandridge did not subtract out this deduction on Schedule CA. The Revenue and Taxation Code Section 17225 clearly states that California does not conform to Internal Revenue Code Section 163, subsection H3 Cap A, that allows a deduction for mortgage insurance premiums. Mr. Dandridge argues he relied on the Franchise Tax Board's instructions that stated taxpayers must subtract out only private mortgage insurance on the Schedule CA. The instructions did not state whether he must subtract out other forms of mortgage insurance. However, the State Board of Equalization and the Office of Tax Appeals have both held that when the Franchise Tax Board's instructions are alleged to be unclear or misleading, the taxpayers must follow the law and not the instructions. Taxpayers should not regard tax instruction pamphlets as authoritative law. In this case, California law simply doesn't allow taxpayers to deduct mortgage insurance premiums. Accordingly, Mr. Dandridge has not met his burden of proof to establish he's entitled to claim a deduction for mortgage insurance premiums, and the Franchise Tax Board's action must be sustained. Thank you.
Do my co-panelists have any questions for the parties? No? Mr. Lund?
Yeah, I guess. This is to both parties. Is there somewhere, either in the Internal Revenue Code or the Revenue Tax Code, or some authority that defines what mortgage insurance premiums are as contrasted with private mortgage insurance, PMI?
Yes.
Okay, Mr. Dandridge, you can go first.
In my original packet, under the Homeowners Protection Act, they defined what private mortgage insurance is. And they state, let me find it here. Oh, it's hard to read on the copy. Let me find my original. Private mortgage insurance. Private mortgage insurance is insurance that protects lenders from the risk of default and foreclosure. It allows prospective buyers who cannot or choose not to provide significant down payments to obtain mortgage financing at affordable rates. It also goes on to state that this act does not apply to mortgage insurance made available under the National Housing Act Title 38 of the United States Code or Title 5 of the Housing Act of 1949. This includes mortgage insurance on loans made by the Federal Housing Administration and guarantees on mortgage loans made by the veterans. When you go and also look at Title 26 of U.S. Code, the IRS, or not the IRS, they break down that they say qualified mortgage insurance. The term qualified mortgage insurance means, 1, mortgage insurance provided by the Veterans Administration, the Federal Housing Administration, and the Rural Housing Administration. And 2, private mortgage insurance as defined by Section 2 of the Homeowners Protection Act of 1989. And then again, in state information, they define the same thing in the analysis done of AB 273, where they define what private mortgage insurance is, and they define what is insurance offered by the federal government.
So, Mr. Dandridge, in your mind, mortgage insurance premium includes PMI or is anything but PMI?
Depends on how it's being used. It's been used interchangeable. The head of the Franchise Tax Board in 2013 clearly pointed out that it was private mortgage insurance that was excluded from deductions.
Okay.
So the federal statute, the title of the section says mortgage insurance as treated as interest, and that's what all the sections in the analysis does. But then they go down to break it down very, very clearly what is because before 2000, FHA loans and VA loans, that interest was my parents had an FHA loan, so that interest was always deductible. They were adding to that homeowners insurance. In 2001, the state was looking at not homeowners, but private mortgage insurance. In 2001, if you look at the analysis of the Senate Assembly Bill 273, they were looking first at, okay, we're going to have a deduction for private mortgage insurance, and then they will, okay, we need to distinguish private from VA, FHA. And these are all documents created by the Franchise Tax Board.
So also in your mind, the mortgage insurance offered by the public entities like the VA and FHA were always deductible as mortgage insurance under the Internal Revenue Code?
Yes, up until 2000, and 17 when they changed it.
Okay. Franchise tax board, is that your understanding also?
So, just to be clear, the Internal Revenue Code, subsection H4 cap E, clearly states that qualified mortgage insurance includes both private mortgage insurance and mortgage insurance provided by the Department of Veteran Affairs, Federal Housing Administration, or the Rural Housing Service. California specifically adopted in Revenue and Taxation Code 17225 that it will not conform to allowing a deduction for qualified mortgage insurance, which includes all the previously stated forms of mortgage insurance.
Well, let's get back to my original question. In your mind, what is the difference between mortgage insurance premium and private mortgage insurance? Are they one the same? Are they subsets of each other, or is mortgage insurance premiums is everything other than PMI?
PMI is a form of mortgage insurance. It just depends on who provides it. In this case, it's separate from the Department of Veteran Affairs, Federal Housing Administration, or the Rural Housing Services versus private entities who provide mortgage insurance. So they're all one and the same. They're all forms of mortgage insurance. It just depends on who provides it.
So when your 17225 says the state of California will conform to the 2010 Tax Act except for Section 163H3 relating to mortgage insurance premiums, you're saying all mortgage insurance products?
Correct. Whether private or public.
Okay. So now I'm sort of confused because Mr. Dandridge was saying that before the 2010 Act, publicly provided mortgage insurance was always treated as interest deductible as an itemized deduction.
Yes, on the federal level.
On the federal, so California never conformed to that.
Correct. California uses specified dates when referring to the Internal Revenue Code, and specified dates basically freeze the Internal Revenue Code as it existed on a certain date. So this would prevent California from adopting changes in the Internal Revenue Code that occurred after the specified date.
Correct.
In this case, for tax years 2005 through 2009, California adopted the Internal Revenue Code as of January 1st, 2005. The provision at issue, Internal Revenue Code Section 163, subsection H3 cap E, was codified in 2006, which is 1 year after the specified date. Now, for tax years 2010 through 2014, California adopted a specified date of January 1st, 2009. This would include the Internal Revenue Code at issue, but the legislature also adopted Internal Revenue Code Section 17225 to prevent California to conforming to that provision. So California never allowed a deduction for mortgage insurance premiums, whether provided by private mortgage insurers or by public agencies.
So what about prior to 2005? I mean, Mr. Dandridge is saying that this FHA and VA and now USDA type mortgage insurance products were deductible as interest on the federal side, at least, prior to 2005. So in the 2005 conformity bill, did the Franchise Tax Board adopt those deductions?
Well, first off, the Internal Revenue Code never adopted IRC 163 before 2006. It was officially codified on, give me 1 second, it was on December in 2006. That was the first time Congress allowed that deduction.
Okay.
Before that, the IRC never allowed it, and California never followed it. And the conformity decision tables and the bills he's referring to, especially the 2007 conformity decision tables, it appears that those are from interested parties meetings in order to determine whether California would adopt 163 subsection H3 cap E, but it was never officially adopted.
Okay.
Any more questions, Judge Noel? Judge Njija? All right. We will now provide closing statements. Mr. Dandridge, we had agreed to an estimate of 10 minutes.
I won't need that.
I will hold you to that.
What is at stake here is some definitions. Working for the U.S. Attorney's Office as an analyst, I look to the documents created by the entities. The Franchise Tax Board is the expert here. The Franchise Tax Board has analyses signed off by individuals working for the Franchise Tax Board. In 2001, it says current federal and state laws do not allow a deduction for private mortgage insurance. They acknowledge that there is a difference between private mortgage insurance and that of federal, paid to the VA, the FHA, or the rural. Clear, bright line. They say private is different than this other. The Internal Revenue Code says the same thing. The reason they can't find anything in the Internal Revenue Code is because prior to 1998, there was no question about private mortgage insurance. Private mortgage insurance came about as an issue in the Homeowners Protection Act. Remember, I read you that act. It said it didn't apply to the VA or the FHA or the Rural Housing Administration. They want to come back and say that these analyses look to be like interested parties. These are out of the booklets published by the Franchise Tax Board. I gave you the cover sheet. Summary of federal income changes. Franchise Tax Board. John Chang, Judy Chu, Michael Ginses, members. Their documents. Their analysts. Their lawyers. They are stating clearly in here what qualified mortgage insurance is. VA, FHA, rural, and private mortgage insurance. Do they use the term qualified mortgage insurance, which would be everything? Because that's what the U.S. Code says. No, they focus on the use of the word private mortgage insurance. In 2010, in the final analysis of the bill that changes the tax code, revenue and tax section, they're talking about private mortgage insurance. They don't say qualified mortgage insurance. Private mortgage insurance. Then when the federal law is changed again, another franchise tax document, John Chang, Jeremy Horton, Michael Cohen, they say clearly and specifically without any ambiguity, federal law, the provision says new federal law, IRC section 163. The provision extends the deduction for private mortgage insurance premiums for 2 years through 2013. Thus, the provision applies to amounts paid or accrued in 2012 or 2013. Effective date, December 31st, 2011. California law, Revenue and Tax Code section 17225. The personal income tax specifically does not conform to the federal deduction for private mortgage insurance premiums. Not qualified mortgage insurance premiums, private mortgage insurance premiums. As a result, private mortgage insurance premiums are not deductible under California law, and taxpayers who deduct such premiums on their federal tax returns deduct for federal purposes must show that as an adjustment on the California Schedule CA. 2013 matches what the book says in 2007, 2008, 29, 10, because if it doesn't, somebody has you-know-what. Those two lines appear over 10 years. And when you go, hey, they're right. Their instructions are not authoritative law, but they give you where to go to find the information. They tell you, go to look under conformity. So I went and looked under conformity. And they have a whole publication. And you've got copies of it. Has a whole list of what these changes are. And at the very bottom, it says private mortgage insurance. Not mortgage insurance premiums. Not qualified mortgage insurance. Private mortgage insurance. So If they know what the law is, they are not fulfilling their duty of care to the residents of the state of California to let us know. If their response is, it's my job, if there's an ambiguity, how's there ambiguity? I've looked through all the information. There's no public announcement from the Franchise Tax Board on the changes. They got all the other announcements of all the other changes, but they don't have this one. It's the same line. Private mortgage insurance. That's a bright line definition. Private, not government. Paid to a private company. Hold it, but I'm responsible for the law. Well, if that's the case, folks, let's just get rid of the Franchise Tax Board. Let's save the taxpayers a whole lot of money because we don't need them because they're not fulfilling their duty of care to let us know what the law is. But the Franchise Tax Board themselves, private mortgage insurance. They know what the difference is because they state it in their analysis, they state it in their documentation, they state it in all the information they gave to the legislature. And the legislature tells them that they must perform that final analysis on any changes, that they must publish it to the public, and they must publish it to the state legislature, the Assembly and the Senate. And guess what? I can't find anything with the help of a state senator's office and a state assemblyman's office that anything was ever done. I reached out to a friend of mine who worked for the Senate Majority Leader's office, and she looked, and she couldn't find anything. So now they want to come back and say, guess what, Mr. Dandridge, you screwed up. You owe because you didn't follow the law. Yeah, I did. I followed the law. I did what I was supposed to do. And I do it every time. Because remember, I'm a public servant. And remember, I got to give information to people. And when I screw up, it's on me. I raised my hand and I took an oath to protect and serve and defend the Constitution of the United States, just like they did. Are you trying to tell me, this Franchise Tax Board trying to make me, hey, we made a mistake? That all these publications that we spent millions of dollars publicizing, all this work of lawyers and analysts looking over these documents over and over and over and arguing them and debating them, that this was missed? Whoops. Guess what? I always thought of California as being a great place to live because we were smarter than the federal government. But we didn't define these terms. The federal government did. Qualified mortgage insurance. As a representative from Franchise Tax Board who was embedded with the Board of Equalization said to me, he says, you're just going to have to get to a level that can adjudicate this because no one at the Franchise Tax Board is going to admit they made a mistake. I make mistakes every day because I'm a human being. And God help me that I don't make a mistake that kills somebody. Because in my 25 years of serving this country, I've had to put people in harm's way. And I've had to go into the White House and brief the President of the United States. And you want to talk about someone who knows something? William Jefferson Clinton asked some serious questions. And if I didn't have the answer, I didn't give him some half-cooked remark. I'm asking you to find that I did what I was supposed to do, that I was entitled to my mortgage insurance premium paid to the Federal Housing Administration because it was not documented as being state law. Thank you.
Thank you. Mr. Kowalczyk, does FTB have any closings?
No, that was my closing. Thank you.
Okay. Well, Mr. Dandridge, I was going to give you the opportunity to respond to FTB statements, but I think you just did.
I have two more things I'd like to say if possible.
Can you do it in 2 minutes?
I can do it in 2 minutes,
All right.
ma'am. At 13 years old, my social science teacher came to me and asked me what I thought about Proposition 13. My father and I, I'm a 13-year-old young man, my father and I argued about what Prop 13 would mean to my school, my future, the future of my kids. I sat on a stage with Willie Brown, who was then the Speaker of the Assembly, and Gray Davis, who was Chief of Staff to then Governor Brown. And I delivered a 10-minute speech about what the impacts of Prop 13 would be. I learned a lesson that day that the unique thing about California is that the people can make law. The people can make changes when those people charged with making the changes can't. We do what we can to follow the rules. We depend on public servants to get us that information. I followed the rules. I followed the instructions. When told that I didn't follow the instructions, I immediately stopped and went back. I didn't say, oh, you're wrong. I went back to find out if I was wrong. And I couldn't find any evidence of that. Any person that I've ever worked for over the last 25 years will tell you that if I'm wrong on an analysis, if I'm wrong on a mistake, I will be the first one to point it out. Here I'm not. I was entitled to my deduction because the state law and the Franchise Tax Board's interpretation of that state law, irregardless of legislative grace, was that private mortgage insurance was not deductible. Thank you.
Thank you. I'd like to thank the parties for providing information and argument today. I'd like to also thank our stenographer and my co-panelists for their contributions to this hearing. The record is now closed to further evidence and argument. This concludes our hearing. The judges will meet, and we aim to send both parties our written decision no later than 100 days from today. The hearing is now concluded. Thank you.
Thank you.
Thank you.